Across America, BP supports more than 275,000 jobs to keep energy flowing. Jobs like building grid-scale solar energy in Ohio and producing gas with fewer operational emissions in Texas. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
The stress and crowds of holiday shopping can put a damper on your holiday spirit, and you don't always find all the perfect gifts you're looking for. The Virginia Lottery's games make easy and tremendously fun gifts for all the adults in your life, even you. Spruce up your gift-giving game this holiday season with the Virginia Lottery. The Virginia Lottery's holiday scratchers are a gift any adult will love. Treat yourself to some winter wonderment and play the lottery's holiday online instant games from anywhere in Virginia. Visit valottery.com/holiday. Please gift responsibly. Lottery games are not for minors. Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Content warning, this episode includes discussion of the murder of 2 girls.
So this week we are going to do a second episode taking some of your questions because we got so many questions and we only got through a fraction of them in our previous episode. So earlier, Anya and I recorded some answers to some of your great questions. Before we get to that previously recorded segment, we'd like to open up by sharing a bit more of our back and forth recently with Todd Click.
Todd Click, of course, is the former assistant police chief of Rushville, Indiana, which is the center of the defense's theory that an Odinist cult committed the murders. Todd Click was one of 3 men, including Greg Ferenczi and Kevin Murphy, who investigated the Odinist angle, seemingly on behalf of the Delphi task force, and he was widely cited in the defense's memorandum concerning Frank's allegations. We reached out to Todd Click a few days ago and previously got a statement from him where he said that the defense was sensationalizing and that no one in law enforcement believes that a ritual sacrifice was the reason that Abby and Libby were killed. But we've actually gotten some more nuanced statements from him that could indicate that he's still interested in the theory that he helped bring forward. So it kind of adds an additional wrinkle, I think, to what's going on here.
So we're going to share that now. Anya will read the questions we sent to Mr. Click, and I will read the answers.
Some people have suggested that while you disagree with the defense that this was a ritual murder, that you have agreement with them on who is responsible. Is that something you can speak to?
Yes, that is accurate.
Other than the material about the cult angle, can you discuss how good a job the defense did discussing the evidence against their suspects?
It would be impossible for me to explain anything further without revealing details of the investigation, but it was fairly accurate.
Since their discussion of the evidence was fairly accurate, can you explain what aspects you feel were sensationalized?
Like I said before, it would be impossible for me to explain anything further without compromising details of the investigation. The defense team seemingly put Ferenczi, Murphy, and I on a pedestal. We did nothing extraordinary. We just did our jobs and followed every lead that we had. We conducted our investigation the way investigations need to be completed. Granted, we were very dedicated to this investigation because the families of Abby and Libby and the community of Delphi deserve justice. As for the allegations against the correctional officers of DOC and Sheriff Liggett, I don't have any knowledge of those details, so I cannot comment.
We asked him if we could use these responses on the record, and he gave us permission to.
He also added, I will also say for the record that I fully support the defense's motion for cameras in the courtroom for transparency purposes.
Yes. So that gives a fuller picture of Todd Click's feelings right now. So we're seeing, on the one hand, he's saying that he generally agrees with what the defense is putting out there in the sense of the facts of the investigation, the conclusions aside from the ritual murder element. And he's giving us some more context about the work he, Ferenczi, and Murphy did. And then on the other hand, he is saying the defense is sensationalizing aspects and perhaps overemphasizing the, I suppose, religious, ritualistic aspect of it. So it's going to be really interesting to see where this comes out. It sounds like, I think we talked about this before when we previously ran his statements, his initial statements to us. It sounds like he's not completely saying, no, I don't think any of this is true, but he's also sort of distinguishing himself from the defense, at least in some aspects. So it'll be very curious to see how this all plays out.
He's clearly saying that what the defense wrote was pretty accurate.
Yeah, so it adds yet another wrinkle. I think a lot of people were like, oh, he disavowed it, so...
And obviously that's not the case.
That's not a
so
full picture.
We appreciate him clarifying that with us and giving a fuller picture.
Absolutely.
And it's given us all more to think about. And
as if you needed more of that in this case.
And now let's get back to our regularly scheduled question and answer program.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases.
We're The Murder Sheet.
And this is the Delphi Murders, the Frank's Memorandum, Questions, Part 2.
This next batch of questions I categorized as legal questions. These all deal with how things should be working in this case, legally speaking, the affidavits and memorandums and filings themselves, and other questions along those lines. To kick us off, here's Lydia. Her question is, are all the affidavits they reference obtaining in this document a standard part of preparing a criminal defense? And when would they secure a deposition versus an affidavit? I thought that was such a good question. I don't know. Hopefully you do.
Well, I mean, it's a dull answer, but it depends. Usually an affidavit is just a simple situation where a person comes in and gives a basic story. A deposition is where a person is basically interrogated, for lack of a better word, is examined about their story to try to get more details about it and perhaps try to poke at it. In this case, depositions done by the defense, I believe, started in August.
Mm-hmm. Okay, so they're parts of the defense toolkit either way.
Yes.
So not unusual, but you don't have to use them every time. Is that fair to say?
That's fair to say.
Okay. Hopefully that answers your question, Lydia. Next, we have a sort of resounding question from a huge squad of listeners. And I'm talking about Christina and Tina and Kim and Rebecca and Amanda and Emily and Tom and Tanya. This huge squad. They all want to know an understandable question. How on earth does this not violate the gag order? Now, what they're talking about is, how does this filing, which is a Frank's memorandum, specifically where a lot of the information came out, but also includes very detailed crime scene descriptions and names of possible other suspects and highlights the defense's entire theory of the case, or at least a lot of it. How is that not violating the gag order? Because it gets out to the media and the media reports on it.
Gag order applies to extrajudicial statements. That's basically a way of saying it applies to things said outside of court. So in other words, attorneys Baldwin and Rosie can't hold a press conference and say things directly to the media that they said in this memorandum. The gag order does not affect what they can say in court, because it wouldn't be proper for the judge or anyone really to try to put limits on how they conduct the defense of their client. So this was a judicial filing, and so it did not fall under the auspices of the gag order. Does that make sense?
Yeah, it's basically, it's everything. The gag order ensures that everything has to play out in court through filings, through hearings. And this is doing that. Whether you feel, I think it's a valid observation to say that it is an effective way around the gag order.
Yes.
That's yeah, I mean, it is.
And you could even argue that it goes against the spirit of the gag order, because the spirit of the gag order was not to try the case in the media.
Right, and this is naming suspects in the media. So it's definitely an understandable question, and I think you could make arguments on both sides. I think the defense, from their perspective, they came into this and then the gag order was handed down pretty quickly, whereas the prosecution had more time and law enforcement had years to kind of say their piece. They kind of jumped into it and couldn't say anything. So, I will be curious. The fact that we're hearing that this order got kind of sealed after it kind of got out to the media indicates to me that the court may not be super thrilled with how this played out.
Yeah, that would certainly be the implication of that. I'm not really sure what the point is of sealing it after it was made public.
Yeah, to use the cliche, that's closing the barn door if the horse is gone. I think the defense obviously made a strategic decision when they decided to include 100 pages about Odinism and their theory of the case and graphic descriptions of the crime scene to the Franks issues involved. I mean, that's a lot of it didn't really have anything to do, in my opinion, with the Franks issues. But it was effective at setting up their theory of the crime, which obviously it's helpful to them when that narrative is part of the media landscape.
Yeah, and certainly prior to this, a lot of the discussion about the case on social media or in the media seemed to be, maybe Richard Allen will plead not guilty by reason of insanity, or maybe he's working out a plea deal even as we speak. And this has certainly shifted the conversation away from those topics. Those topics presuppose that he is in fact guilty.
Right.
And the defense has always maintained from day one, no, this is a case of a man who is factually innocent of the crime with which he's been charged.
And I think it kind of gives them some control of the narrative, because now you have a lot of people who are just wholeheartedly accepting that it's Odinist. Or they're saying, well, sure, we accept that there are Odinist runes at the site, but maybe Richard Allen was an Odinist. And I'm going to tell you guys, I mean, the defense does their due diligence, I'm sure. They're not going to throw out the Odinist theory if there's any chance that this guy's an Odinist, because that would be disastrous for their defense, right?
Yes.
That's just an own goal.
The defense is not going to say this crime was done by Odinists if, in fact, their client is an Odinist.
I just find it fascinating that people are trying to make both work, and I think it's like, that means that you've already accepted the defense's premise that the different things at the crime scene are definitely Odinist in nature and not just, being viewed through an Odinist lens. Also, we are so sorry for saying runes wrong. We don't know how to speak, and this happens a lot, but we appreciate the people who reached out and said it's runes, not ruins. Nicole Haley and Caitlin asked a similar question, similar to each other, saying, will the state be allowed to dispute the claims presented in the motion, or will it have to wait until trial? Great question.
The state is allowed to dispute those claims. anytime one side makes a motion for anything in a case, the other case gets an opportunity to respond.
Let's go west for a minute, go to Idaho. There were a lot of claims from the defense in that situation. Like, the FBI agents were intimidating our witness, and then the prosecution was like, that's because your witness said that she signed something that she didn't mean. And so, like, in situations like that, let's look it up. Like, it's like a tennis match, they're allowed to, it's back and forth, back and forth, back and forth. Remember the transport issue. The defense filed a filing in April saying, look at our client. He looks terrible. This is a disaster for him. He should not be in prison. And then a long time later, the Nick McClelland, the prosecutor, responded to a lot of the allegations in a hearing and sort of pushed back against some of those narratives. So we don't know how it's going to happen in this situation. We really hope that we don't get into a situation where the response is sealed, because then that would sort of defeat some of, I think the public should know what's going on in this case.
And keep in, this was a motion for a hearing. So there will certainly be a hearing on the Franks issues.
Do you think it'll come to a hearing, or do you think it'll be dueling filings at this point?
I think it'll come to a hearing.
Yeah.
These issues are serious enough that I think they deserve a hearing. I think both sides really deserve a chance to air it out in front of the judge in person and in front of the public.
Yeah. Nicole asks, in your opinion, do you think there has to be something damning that the police found in the search other than the gun? Otherwise, why would they be fighting so hard to get the search evidence dismissed? So it's sort of a strategic question. I think the gun itself is important enough that the defense has every motive to fight as hard as possible to get that out.
Yes. The gun, if we accept the analysis of the state police, the gun ties Richard Allen to the crime scene. And it is the only piece of physical evidence that does so.
And we're seeing them fight the gun in the motion in limine, where they're saying ballistics is junk science. And again, every prosecutor or cop is going to tell you that ballistics is the best thing since sliced bread. Every defense attorney is going to act like it's just, witchcraft used in the, Inquisition. I think we're in a place where we're kind of just like, whatever, like let's let it play out. I don't really see in Indiana ballistics being thrown out. I don't really see it like on its face. But I also can see a really good defense expert coming in and casting doubt on it. I think that is most likely. But this is more about like attacking it on its, okay, we want to get the gun thrown out by attacking the search warrant itself. You never should have gotten that gun.
There are hints in here of another possible attack on this evidence. There are hints in here that there may be chain of custody issues on the bullet. So they may possibly move to attack the bullet evidence on chain of custody issues as well. So the fact that they're attacking this bullet ballistics evidence from on so many different fronts just shows how important it is to the defense to get rid of this bullet evidence.
Yeah, so I don't think there is anything else damning that they need to have found. I mean, there could be that we just don't know about, but I think it could just be the bullet. Mel and Emily want to know, what would the possible repercussions be if the defense is greatly exaggerating what they have found? Okay, so if they're exaggerating the Odinist claims and the, here are these people associated with an Odinist cult, and also there are guards who are torturing Richard Allen to say things in prison claims. And if they're exaggerating that, I mean, I think if Nick McClelland, if there's a big response in that there are allegations of exaggerations or whatnot, I think probably you could get into a situation where the credibility of the defense could be questioned. I think some people have, we've seen both sides. I think some people feel like the prosecution may have a credibility problem, and some people feel like the defense could have a credibility problem. So I think you're just going to get people getting harder opinions on both sides potentially. I mean, I can't really think of anything other than that, though, right?
Yeah.
They have to be strenuous in their defense of their clients. So, sometimes that looks like exaggeration to everyone else, but, that's kind of the job.
Yeah, they have to defend their clients in as vigorous a way as they can.
Yeah. Amanda and Jody ask, please explain the Franks hearing. If a judge agrees the search warrant was requested with withheld or false info, what happens? Can charges be dropped with prejudice? Will the state move forward with the trial? Thanks. Great question. I think if they lost the bullet, I don't know. If they to me, they would lose the bullet and the confession because he only confessed because he was in prison, which was because of the results of the search warrant. So I think you'd have a hard time taking that to trial.
Yeah, I think you would too. And if the prosecution believes Richard Allen is guilty, they might say, we want to drop the charges. We might want to refile them later. I think we saw something similar to that happen in the Morphew case, didn't we?
We did. Yeah. A man was accused of killing his wife. Her body's not been found. Police charged him and the prosecutor charged him seemingly with the anticipation that they would find the body. They did not. Then they dropped charges. That is the prudent thing to do for a prosecutor. It's very frustrating for the public if people are convinced someone's guilty, but you should not bring a case to trial that you're not confident that you can win.
And it would be challenging to bring this case to trial without the bullet and the confessions.
Kylie and Jenny asked, along with that, if charges are dropped, can they refile in the future if they obtain more evidence? If the warrant is thrown out, how could the state move forward? And, where does prejudice without prejudice kind of get into the mix there? So, yeah, if they drop charges, my understanding is they could refile in the future. If they had, I suppose if the judge at some point dismissed the case with prejudice.
If the case is dismissed with prejudice, they couldn't be refiled.
Yeah, so that would be the kind of game over for the prosecution side.
At the Murder Sheet, we spend so much time digging into crime stories that sometimes it's difficult to find the time to plan out and cook elaborate, nutritious meals. That's why we are so excited about our sponsor, Factor, America's #1 ready-to-eat meal delivery service. Our sponsors make this podcast possible. So if you go to factormeals.com/msheet and use our special code MSHEET, you're not just getting half off this high-quality meal plan. You're supporting us too.
So I'm obsessed with Factor. I had their creamed corn chicken and their tomato basil chicken risotto recently. Both were delicious. That risotto in particular was amazing. Plus, the whole process was a breeze. All I had to do was pop the meal into the microwave. The food was tasty and flavorful, which is no surprise given that each recipe is specifically crafted by chefs and approved by dietitians.
Having Factor during the hectic holiday season has been a boon, especially with us pumping out so many episodes. Head to factormeals.com/msheet and use code MSHEET to get 50% off. That's code MSHEET at factormeals.com/msheet to get 50% off.
Hey listeners, this is Candace DeLong, the host of Killer Psyche. Imagine all your audio entertainment available in just one place. That's what the Audible app is all about. With Audible, you can always find the best of what you love or discover something new. Audible has an incredible selection of mystery and thriller titles and originals like Something Ain't Right by Roger and Zachary Stringer, The Space Within by Greg O'Connor and Josh Fagan, and Moriarty, an Audible original. Membership includes access to Audible originals, podcasts, and tons of audiobooks that you can download or stream as much as you want. And as an Audible member, you can choose one title per month from an ever-growing catalog of titles to keep. The Audible app makes it easy to listen anytime, anywhere, whether you're traveling, working out, doing chores, wherever your day takes you. New members can try Audible now for free for 30 days. Visit audible.com/DeLong or text DeLong to 500-500.
Charmaine asked, I would like to hear Kevin's take on the memo. As a lawyer, do you think the defense would have filed something like this without substantial evidence to back up some of the more serious allegations against Liggett? Or are they blowing smoke? I want to emphasize substantial evidence, not just how they perceive the information they've collected. Is this real? What are the potential consequences of bringing these claims if they're unsubstantiated in the court's opinion? I love how detailed this is. And it's all for you, Kevin. I don't have to, I can just sit back here.
That's right. These are very good defense attorneys. They're not going to file something that they can't subsequently defend. So they're going to only put stuff in there that they can argue is accurate.
Argue seems to be doing a lot of work there, though, if I'm being a bit of a devil's advocate here.
They can't put in stuff that they know is untrue.
So, okay, let's give an example. If they wanted to, they would not put in, I think that former President James Garfield did this because they know him to be dead for hundreds of years, right?
Yes.
Okay. But I think in a case where there's a lot of questions, there's room for putting out alternative theories. And it's one of the alternative theories that is probably more surprising because it's more complicated and far-flung and vast and conspiratorial than other ones that have come up, like Ron Logan being guilty.
And it's also surprising because it's an alternative theory that has not gotten as much oxygen as some of the others have.
Perhaps because it's so out there.
I think most people who have followed this case have heard about the Ron Logan theories or some of the Klein theories, but maybe they've not heard about the Odinism theories.
But when Charmaine asks about substantial evidence, do they need to prove Brad Holder guilty beyond a reasonable doubt in order to run with him?
No.
What do they have to, is there a standard that they have to meet in order to run with somebody as an alternate suspect?
They're not even saying that they believe Holder committed these crimes or inspired these crimes.
They're saying he's Charles Manson.
They're saying he could be Charles Manson.
Yes.
They're saying we don't think the state investigated everything else as thoroughly as they should have. And here's an example of something that we feel they didn't investigate thoroughly. So they're not explicitly saying that they believe Holder is a murderer.
Okay. I think the public probably has a different read on that, but I understand what you're saying.
They chose their words very carefully in this memo.
They are lawyers.
Yes.
Yeah, I think, I think there's a lot of flexibility. There should be a lot of flexibility in what you can do in defending your client. So
you don't want to shackle defense attorneys in the defense of their clients. They need to be able to do their job.
Do whatever they need to do.
You don't want them to say things that aren't true, but if there are areas where something could be true, they should have the right to pursue that.
Do they have to be worried about people like Holder suing them for maligning them as Odinists who are child murderers? Or at least maybe.
Generally speaking, there's a substantial amount of protection for things that are said in court filings.
So in a court filing, you can pretty much do what you want.
So in a court filing, I can say Anya Kane robbed a bank and Anya Kane couldn't sue me for that. But then if I stepped out of the courthouse and on the courthouse steps, I said, oh, by the way, Anya Kane robbed a bank, then Anya Kane could potentially sue me for that.
But of course, there's a gag order, so, darn the luck, you can't go out and say that.
Yeah.
So I can't sue you. Drat. I'm out of options here.
Yeah.
That's interesting, though. So they're not necessarily bound by the evidentiary thing when it comes to naming people, and there's also no consequences, I guess, except in the public eye if the public deems it to be not credible.
Yes, if if Nick McClelland comes up with some slam dunk response to this, it's going to make them lose credibility in the eyes of the public. If Nick McClelland does not come up with a slam dunk response to this, I think it damages Nick McClelland.
Yeah, it
and
does.
Nick McClelland loses credibility in the eyes of the public. The filing of this memo really is a crisis moment in this case, because how this plays out is going to forever after influence public perceptions of either the defense or the prosecution in this case.
So it's pretty important. All right, let's move on. Janine had a question. Assuming R.A. is guilty, and she acknowledges he is currently innocent until proven guilty, yes. But if he were to be guilty, this motion would be absolutely outrageous, especially considering all the horrific details that were made public and how the families must be feeling. Just terrible and hard to imagine how anyone could be so cruel as to make details like that up. In your experience, how likely is it for a defense to resort to this kind of story? We don't know if they're making it up, and I appreciate your balanced and fair reporting. I just can't fathom how they can make allegations this shocking. It strikes me as being outside of what would be normal defense lawyer behavior, and was just wondering if that is actually the case. I understand the emotional reaction to the details. I had a similar thing. Reading about what happened to Abby and Libby is horrifying, and it's undoubtedly very hurtful to the families. I will say, in the defense's defense, a lot of these details would come out one way or another in trial, most likely. And that shouldn't change how they feel. I'm not even saying that in response to that. It's just more of like, it's fair to say a lot of this would have come out at some point. As far as like who could make up details like this, or, I think we just have to see everything through strategy. Everything the prosecution is doing is strategic. Everything the defense is doing is strategic. And when you're kind of, I see some of this with the Odinists. I think characterizing the Odinists as these really creepy dudes who are like celebrating a religion that a lot of people don't understand and may in some cases really be connected to like white supremacy. And then it's offering people a very potentially easy to believe bad guy who's an alternative, compared to Richard Allen, who by all accounts, seemingly normal guy, working a job, raising a family, not displaying any of those red flags. So, I mean, I think including shocking details and a story about really potentially creepy people kind of works in that situation, because it's a strategic move to say, stop looking at our client, look at these other creeps. You guys didn't look into them enough. That's my take.
Yeah, I agree with what you're saying.
Jill and Anonymous want to know, in your opinion, is there any truth in this motion? So blunt. And also a question for Kevin. Is it typical for lawyers to blatantly lie that their client is not guilty when they know for a fact in their head with the evidence that he is guilty? I think it's important to clarify a lot of this.
We're first of all, if I know, if my client is Anya, and
bound to happen at some point.
Yes. If my client is Anya and Anya tells me, oh, I robbed this bank yesterday at noon. And by the way, here's a photograph of me inside the bank yesterday at noon holding a gun. I can't then file a motion saying Anya was nowhere near that bank, because in that set of circumstances, I have information that she was. And so I know for a fact that what I'm saying is untrue. And you can't misrepresent things to the court. You can't lie to the court. But there is a distinction there that sometimes is hard to understand. But there's certainly a distinction there, because let's say Anya doesn't tell me she was in the bank at the time. She tells me she was framed. then I don't know what's true. I haven't seen evidence of it. So I don't know that she, in fact, is guilty of the crime. So I assume she's innocent of the crime, and I move forward on that basis. So I wouldn't be lying to the court. Maybe I'm saying things that don't sound plausible, but they're not knowingly untrue.
And you got to go with the thing that makes your client innocent, right?
Yes.
There's a movie out there that it was kind of an interesting view of interesting courtroom drama, and it was written by a judge, I believe. The book that it's based on, it's called Anatomy of a Murder, and it stars Jimmy Stewart, and he's a former prosecutor in the film who's now become a defense attorney. And in the case, no spoilers, but in the case that he takes on, that's the center of the movie, he goes in and the defendant starts telling him his side of it, and he just is like, stop. Like, the more you tell me, the less I can help you. So let's work out a defense. Like, if he starts talking himself into a corner, then they cannot use the insanity defense, which is what he ultimately wants to use here. And if this guy's saying, yeah, I wanted to kill him, then that's not gonna... I was totally in my right mind. That's not going to help him. So sometimes there's a level of strategy that can go on with criminal defense.
Yeah, and I'll even note,
as there should be. You have to be vigorously defended by somebody when you're accused of something horrible. I mean, it has to be fierce defense.
I'll even note that there's a moment in this memorandum where they suggest that Richard Allen confessed to the crimes because he was pressured to do so by the guards. And the fact is, they make clear they never ask Richard Allen if that's why he confessed.
They're just speculating.
Because if they did, and he said, no, that's not what happened, then they can't use that argument.
Right. So, I think a lot of people who are lay people, and frankly, I count myself in that. I feel like getting to know you, I've learned more about the legal field and like talk.
Because I'm very scheming.
You're very
scheming and manipulative.
I never know. Yeah, well, I've become a much better arguer. It's, because it's hard to argue with a lawyer spouse, guys. You gotta get tricky, but it's a situation where there's a lot of nuance there. And so when, people ask us, can they just lie? No. But there's not every defense attorney who's represented someone who's guilty is just straight up lying, but they have to go with the version that makes their client innocent. And maybe it sounds very plausible. Maybe it doesn't sound plausible at all, but they have to go with that. And they have to be fierce about it. They have to be really amped about it, because otherwise that person may not be getting a very good defense.
And it's important they get the best defense they can, because if your goal is justice, if your goal is that the right person be convicted and serve time for a crime, then you want that person to be thoroughly and well defended, because that way everybody will have more confidence in the final outcome.
To get super medieval, let's just say, like, just in the metaphor of if it's a trial by combat, you don't want to have the prosecution being some beefy guy and then the defense being like some guy who, doesn't know how to fight, because it's going to be really one-sided, and the person whose rights are at stake, whose life is at stake, is going to be essentially just sacrificed because all the power's on one side. You want somebody who's going to be a fighter and who's going to try their hardest to get their client out of this situation.
Exactly. And certainly when we see how hard attorneys Rosie and Baldwin have worked in behalf of Richard Allen, I think we can agree that if, speaking hypothetically, Richard Allen ends up getting convicted of this crime, we would probably be likely to accept that verdict.
Yes, because we know he wasn't just thrown to the wolves, essentially.
And if he is acquitted, we would accept that as well.
Their job is to raise reasonable doubt. Their job is to raise hell on behalf of their clients. So that is ultimately what it's about. But it also doesn't mean that, every word. I mean, they acknowledged at one point in a footnote that, as Kevin pointed out, that they didn't really ask Alan that. They're just speculating. So is every word of the, everything about the Odinist cult spot on? We don't know. We're going to try to look into it. But it's certainly what they believe, and it's certainly what they feel is the best route for their client to achieve freedom. So I think that's what there is to say. And then JR and Trisha asked similar questions, and it's more of kind of like about the Franks motions, verbiage, language. Is it normal for the Franks memo to be written in such casual language? What I mean by that is it feels very biased and persuasive, which I understand is the job of the defense team, but it almost seems slanderous and unprofessional in some areas. I know lawyers are given a lot of leeway when making opening and closing arguments, but in other circumstances, especially in written motions, I thought they'd stay more in the realm of just the facts and avoid all those colorful adjectives. And then, is it common for memorandums to be so unprofessional sounding? He said, she said. It honestly sounds like a child not getting his way with some of the comments that are made throughout. Yeah, so it's definitely, I think, in my view, like a colorfully written document. And definitely for somebody who's expecting more of like a dry legal briefing, it's not that at all. I think, I would guess that a lot of things can be written a bit dryly so as to not tick off a judge, right?
Right. This reads a little bit like it.
Very personal, almost.
It reads like an argument that an attorney would deliver in court to a jury.
Yeah.
Where it's very personable. It uses common language.
Repetition.
That ordinary people, lay people can understand.
It's written for the public. It's written for the media, I think. I mean, because the media and the public can understand this. Whereas sometimes you have to parse legalese. And what the heck does this mean? And then you look at it and you're like, oh, that is really kind of sassy, but like it's lost within the language. The language is very blunt here. I think that speaks to this being a strategic move to put the narrative out with the media and the public. So, yeah, I would say that it's definitely interesting, but sort of makes sense when you think about it that way, I think. I don't know. I'm just speculating. Maybe they're arguing to Judge Gull. I see it as more of it's accessible. It's making it accessible.
Which is part of the job of attorneys to do.
Cindy asks, how do you feel the Franks motion and the allegations included in it will influence the potential jury? And 2, can any of these reference allegations be brought up in court if the judge does not decide in the defense's favor? Okay.
Well, in theory, it should not affect the potential jury at all, because in theory, the potential jury is not seeing this.
If you are listening to this show right now, you cannot be on the jury for Delphi.
Because basically, if you're listening to this show, you're an intelligent person with great taste.
Obviously.
And
you're the best person alive.
You're also what we would consider to be a high information person about Delphi. In other words, you're familiar with the case.
You probably have opinions on the case.
And so that's not someone that the judge wants on a jury. What they want on a jury is a person who is kind of a blank slate, because whatever evidence is used to either acquit or convict Richard Allen should only be evidence that's brought up in court.
Yeah, you shouldn't be like, but I remember that murder sheet episode when they were saying some really good point that was amazing. I'm just kidding, obviously. But you shouldn't be thinking about that. You should only be considering what is in front of you. Really hard to do that when you have a whole Wikipedia's worth of information swirling in your head about all the different suspects and all the different theories.
And as much attention as this motion has gotten, as much attention as this case has gotten, there are plenty of people out there who are not familiar with the case at all.
Yeah.
And those are the people they want on the jury.
Yeah, and that sounds bad, and I know like true crime podcasters are always like, "Oh, that's terrible," because then they don't know anything. But it's good because, like, think about it, like from a sports fan view, like if you had something where like you've already made your mind up about what teams are really good or what players are really good, like you it's kind of better to get a blank slate, I think, because the person has not already made up their minds. And I know all of us try to be open-minded, but that can be very difficult when you are in the weeds to the extent that we all are as true crime people. So I think it makes sense when you kind of see it in action. I was really struck. The Bob Adair case that we covered, the murder of Bob Adair in Brown County, that jury just struck me as like so like smart. Like they just seem to be like absorbing everything, getting it, like being open-minded, and the voir dire kind of revealed that. And I had such respect for them because they weren't like sitting around following everything in crime, but they were able to still come to a decision together based on the evidence. And that's what ultimately it's all about. So, yeah, we love you, true crime people. We're the same way. We will never be on a jury because of what we do. Kevin also can't be on a jury because he's a lawyer, but I can't be on a jury because if I get up there and I say, "Oh, what do I work at?" The murder sheet. And they're going to say, "Get out of here. That's embarrassing." And then they're going to throw a book at me and then I'm going to run out. And that's how it's going to happen. Apparently the prosecutors don't like journalists either because we ask too many questions. Isn't that what you said?
Yeah, generally speaking, the prosecution. This is all generalities.
The total generalities.
Generally speaking, a prosecution likes jurors who just accept things. Defense attorneys like jurors who ask a lot of nitpicky questions and challenge everything.
That's me.
Yeah.
As
I well know.
Put me on blast. Okay. So, great question, Cindy. And, she also, part 2, if Judge Gull says, if Judge Gull gets Nick McClellan's response, and is like, "I believe Nick McClellan, not you guys," they can still use the Odinist stuff. That's just their theory of the case.
Yeah.
It doesn't bar them from using that. It just means that the Franks, they're not going to get the search warrant thrown out on a Franks issue. Stephanie asks, is the Franks motion now sealed? Was it not supposed to be released? We've heard that it's sealed. It was supposed to be released because it was not filed under seal. If it's not filed under seal, that means the defense attorneys don't think it needs to be sealed. And typically that's how it works. The attorney filing it is the one who's supposed to seal it, right?
Right.
But it might mean that the judge feels that maybe it should have been, so I guess we'll see what happens. Have you ever heard about the supposed runes prior to the release of the motion? Yes.
Yeah, we'd heard about these for a while.
But it's hard to assess things, especially with crime scene things, because people just make stuff up on the internet. So do you think the defense now has raised reasonable doubt? We don't know. It kind of depends on some things about the prosecution's side of things. I think that's way too early to answer that.
Yeah, Anya was talking about sports earlier. Let's imagine this is like a baseball game. And in the top of one inning, one team gets a couple of hits and a run crosses the plate. We don't say, okay, well, the game is over now because one team scored a run. You wait till the bottom of the inning and you see how the other team does. And a lot of this is going to depend on how the prosecution responds to this. Frankly, some of these allegations raised in this motion seem very serious.
And you're talking not about the Odinists, but about the Franks issues.
Yes. They need a response. And so what I'm wondering is, does the prosecution have a compelling response? If they do, and a lot of this goes away, then no, there's no reasonable doubt raised. But if they don't have a compelling response, then who's to say?
Christina asks, if the defense team is... Oh, this is a doozy. If the defense team is hiring people to go on sites like Reddit and Facebook to pose as armchair detectives and talk about how innocent RA is, which I 1,000% think is happening, does that violate the gag order since they're paying people to get their message out? Christina, I don't think we can say this is happening. I want to address this because I will say I know that there are groups out there that claim to be the recipients of the defense's largesse here, but I really have a hard time believing that there's a direct connection there because I think that these people are dumb, and I don't know why you would hire people like that if you're smart attorneys. So, yeah.
And we have some personal experience here because we've been made aware that on some subreddits, there are people who have some complicated and convoluted conspiracy theories where Anya and I are some puppet masters of the subreddits, and we're somehow manipulating things with sock puppets and fake accounts to get other people banned and things like this.
Yeah, that we have a lot of time to do that.
And the fact is we don't even go on Reddit anymore. So
I go on Reddit, but just to see like DIY project tips because I'm not very handy, so that's helpful. But that's just not as an account user. That's just like Googling Reddit.
So if people are accusing us of using sock puppets to do things on Reddit that we're not doing with no proof, and I know that those things aren't true.
Well, I'll tell you. I mean, Christina, I think, is on the money here in the sense that people are claiming to be working for the defense. That is the cat is out of that bag. People are totally claiming that, and I've seen that, and I think it's embarrassing because it's like, you guys are their junior detective squad. Like, are you serious? Like, I mean, could they find like anybody else to do that? I don't buy it. I guess what I'm saying is people can claim that, but if they're just making it up, that doesn't make it a gag order violation, if that makes sense.
Yeah, and I'm saying we get accused of stage managing and being puppet masters. It's not true, and perhaps the same thing is true with these sorts of claims. And also, there are, again, gray areas in distinctions. Maybe if I'm a witness or a potential source of information or a researcher on the case, and the defense sends an investigator to talk to me, and that investigator says, oh, you have some good points, maybe you should feel free to share those with the world, then in that case, I'm not officially working for the defense just because an investigator has encouraged me to share something. So that wouldn't be a violation of the gag order.
Right.
Now, if one of the investigators who's being directly paid by the defense is going on Reddit and saying things, that would be a problem.
Yeah, that would be a problem. So hypothetically, yes, big problem. I gotta say, though, I think a lot of the people who are claiming this are full of it. Joe asks, my biggest question is, where is all this information coming from? Is RA giving up all these people's names and specific information about them? Is the defense digging this up on their own? Well, Richard Allen's not giving this information because this is meant to prove that he's innocent. So the defense is conducting their own investigation and drawing from either previous investigations that the police did or stuff that they're turning up on their own, depositions with law enforcement, things like that. So that's sort of where the information in this memorandum came from. Is that a good summary, Kevin?
It's a great summary.
And I'll do one more. Nikki asks, how does the motion filed by Ari's defense help or hinder the state's case? What do you think about that? I think it depends on like what ends up being accurate in it, right? If it's like totally on the line about the witness statements and like they got them, then that's disastrous for the state's case.
Yes. If Judge Gull finds this compelling, and if Nick McClelland is unable to come up with a good response to this, then the state potentially loses the bullet and potentially loses the confession. And that would basically really weaken, if not destroy, the case against Richard Allen.
Yes. And, it's a situation where I say, it depends on the facts. It's not even,
Like I say, think about it as an inning of a baseball game. We've had the top of the inning. The defense has come out. They've made some attention getting plays. Now they've gone back to the dugout, and it's time for the prosecution to come forward. And whether or not what the defense has done is going to prove to be the beginning of the end of the case against Richard Allen, or whether it turns out to be something much less than that, it's all going to depend on what prosecutor Nick McClelland does next.
And also what the facts are, what the underlying facts are. If he can point to and say, this is not true, this is not how it went down, there's an alternative explanation for this, then that's obviously very different than if he's just like, well, so I think that should make people, ultimately the facts are kind of what's most important here. Emily asks us, well, first she apologizes for not doing her due diligence. Emily, no reason to apologize. She asks, these new defense filings are obviously shocking. I'm trying to keep my head level about it and acknowledge that the defense team has no obligation to prove that someone else could have committed the crime. They just need to create reasonable doubt. Without any response from the prosecution at this moment, I'm wondering what to make of it all. You guys got into it a bit with the memorandum episode, but my questions are, if the defense would be so reckless as in making baseless allegations to the judge, how much of the memorandum could be the defense editing their own evidence? At one point, are they risking their careers and reputations? Would they raise concern about Brad Holder being immediately dismissed if they didn't have evidence to demonstrate exactly that? I think that's the piece of it that's most concerning. Stripping away all the conspiracy, there still lies the issue of evidence against Rick Allen and potential evidence and leads that were not followed up to the fullest extent. Am I stumbling into the defense's trap by thinking about that? Emily, I think it's a really great question. And it seems like you have an open mind and are kind of weighing different options. So don't worry about that. I think we shouldn't, as a collective, I don't think we should be thinking about any of this as like the defense's trap, or, oh no, we all are, if we don't believe it, we're all complicit in the Odin conspiracy. I think we should be thinking about it more like, let's just like hear everybody out, As for, I think we've addressed a bit about like repercussions, if there's stuff in here that's not really well vetted or very realistic, could it hurt their credibility? Yeah. Will it hurt their careers or reputations? I mean, I think a lot more would have to happen before anything like that would happen. In my mind, I don't know. This is a shocking filing. There's a lot of in it that's shocking, and I can understand where some people could be upset about the graphic nature of it. So in that way, maybe reputationally, some people might not be super happy with it right now. But like, I think ultimately a lot of things get excused with defense attorneys if they are in the service of robustly defending one's client. And that's just the way it is. And I think that's the way it should be, because you have to give people the leeway to do that job. It's not an easy job, and it's a very important job. Now, okay, so the kind of other element with Brad Holder, I think one thing that's important to remember is no, they don't need to prove Brad Holder guilty beyond a reasonable doubt here. A lot of what was included about him in here was there was a personal connection with Abby, which is important, but a lot of people may have had personal connections with her, and obviously that doesn't make them guilty. The other thing is participation in a creepy subculture. I'm calling it creepy. I don't mean to say that Odinists are creepy. I'm sure we're going to talk to some very nice neo-pagans soon, and they're going to give you a sense of their culture. And I'm talking about like the way he's posting about it, I think struck a lot of people as pretty creepy. Right?
Yes, that's fair.
And people don't like that. And it also, like, people are all over our inbox now saying, look, you're a creepy post from him. And it's like, okay, thank you for sending us that. I appreciate it. But, okay. I guess, I don't know. I'm so burned out by Burger Chef. I've seen all sorts of weird Facebook posts in my day, so I just don't really think that much about stuff like that. But it gives the public something to do, something to sleuth. So I think that's why people kind of like that. They don't need to really, I mean, they even acknowledge that Brad Holder was likely at work during the murders. They kind of put out like, oh, maybe someone clocked in for him, but then they're like, but he could just be Charles Manson. And I think once you're throwing Charles Manson in there, we're kind of getting into the realm of like, this was a huge conspiracy and had many moving parts. So I'm just throwing that in there. What do you think, Kevin? As far as like, would they accuse Brad Holder without sterling evidence?
Again, I think their hypothesis in this brief is not that Brad Holder committed these crimes, but merely that this was something that should have been investigated more thoroughly than they believe that it was investigated. And so if all you're doing is saying this should have been investigated more thoroughly, then you're not making any accusations of ultimate responsibility.
I understand what you're saying, but let's think about this from a more populist view. The defense is putting out their names of people they're saying who are Odinists. They are stating outright that Abby and Libby were murdered in an cult sacrifice, and they're saying that they're likening Brad Holder to one Charles Manson. So, I mean, I don't really feel like they're necessarily being as subtle as you are right now. But I appreciate what you're saying because it's not their job to convict anybody. It is their job to make sure that Rick Allen does not get convicted. And so it's
their job to create reasonable doubt.
Viewing this in the service of that contextualizes some of it, I think.
Yeah, that's fair.
But I think, when you write 100 pages about the Odinists, I think we should take the Odinists and run with that because that's a huge part of what they're saying right now. And they're saying that, in my view, they're pointing a finger at these men. Is it typical for the prosecution to wait 9 months and still not have given some of the case file to the defense? Asks Cindy. In terms of discovery issues that are raised, which are concerning in the document. We've seen Judge Gull throw out cases based on discovery issues in the past.
Yeah, this is a serious allegation. So this is a serious allegation. You would expect all of the discovery to be turned over by now, but keep in mind that new investigation into the case has been ongoing as a result of some of the concerns raised by the defense.
Right. So they have to turn over that new work product that may be in the process of being formed.
Yes.
Okay. But if it turns out that there's serious discovery issues in this case, then that's going to be a huge problem.
If it turns out that there is information out there that would tend to exonerate Richard Allen that the prosecution has not turned over or turned over in a dilatory fashion, these things would be significant issues potentially.
Candy asks, is the source that Allen's prison guards wore white supremacy patches the same college intern who reported false information about Allen's prison conditions? She's going after Max. No, he seems to be one of the college intern who worked with Brad Rosie seems to be one of the people who's kind of listed as a witness as far as the, patches. One other thing is a lot of people are like, well, how would Richard Allen know about it? No, it's an Odinist patch. It says "In Odin we trust." It's not like a symbol. It's like it says Odin in it, right?
Yeah.
So, in fairness, you don't have to be an Odinist to be like that's about Odin. But yeah, so it seems to be like the defense team is putting themselves in the position of witnesses here. So that's interesting. Maria asks, is it possible for the defense to file something as sort of smoke and mirrors to throw off the prosecution? Yeah, I mean, the defense can kind of do what they want in that sense, but it makes sense to not just be doing something to troll the prosecution. It makes sense to also be making the argument to the judge, right? And so I think if I had to say something that might throw off the prosecution, that might be the Odinist stuff, the 100 pages outlining their entire case. And I think the stuff for the judge is more of the items that deal with the Franks issues. So I think they seem to kind of be doing both here, in my view.
Yeah, I think so.
I don't think it's just for one or the other. And Jenny, Christina, Heather, and Laura all want to know, can Brad Holder and the other people named as Odinists, or at the very least as people that should have been looked into more as Odinists, can they sue for libel? Can they sue for slander or libel?
Almost certainly not, because there is basically a large amount of privilege granted towards the contents of court filings. So if you say something in a court filing in the course of defending your client, that is generally speaking protected, because you don't want to have a situation where a defense attorney's hands are shackled and they're not able to defend their client as vigorously as they want because they fear a libel or a slander suit.
Yes.
Now, if the defense attorneys were to leave the courthouse and go across the street and repeat some of these allegations, perhaps that would be a different matter. But again, I know you tell me I'm being too nuanced, but that they never actually say that Holder committed or inspired these murders.
I think people are going to hear that and they're going to be like, Kevin, they basically said it, and that's ultimately, people are running around stalking Brad Holder's Facebook posts and sending us screenshot. The goal is to focus guilt on him and present the Odinist as an alternate suspect, even if they're not explicitly saying that. But yeah, these people have no hope of suing, and there's probably been a lot of noises made about that, but I don't see how that works out. It would take the defense attorneys coming out and saying, on the steps of the courthouse, they're guilty, and they're not going to do that because they can't, because there's a gag order. So it kind of inoculates them from any repercussions for throwing these guys out there. So the only real recourse they can have is to tell their stories to the public. So hopefully they, if any of them want to talk to us, murdersheet@gmail.com. Let us know. But otherwise, not going to be a legal respite there, which I think might strike a lot of people as kind of sinister, because you could be doing your thing and then one day people decide to use you as a alternate suspect in a case and you can't do anything about it. But I think, as Kevin said, it's really important to the system that defense attorneys be allowed to do what they have to do, even if that means potentially doing stuff that could, wreck other people's lives in some way. We got through all of our legal questions. We'll be continuing this series with a couple of other categories. And we just want to say thank you all so much for your great questions. We appreciate it. Gives us stuff to think about. Hopefully it gives you stuff to think about. And hopefully at the end of the day, we can just all keep an open mind about this and see where it takes us.
Thank you so much.
Thanks.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
Subtle results, still you, but with fewer lines. Botox Cosmetic, out of botulinum toxin A, is a prescription medicine used to temporarily make moderate to severe frown lines, crow's feet, and forehead lines look better in adults.
Effects of Botox Cosmetic may spread hours to weeks after injection, causing serious symptoms. Alert your doctor right away as difficulty swallowing, speaking, breathing, eye problems, or muscle weakness may be a sign of a life-threatening condition. Patients with these conditions before injection are at highest risk. Don't receive Botox Cosmetic if you have a skin infection. Side effects may include allergic reactions, injection site pain, headache, eyebrow and eyelid drooping, and eyelid swelling. Allergic reactions can include rash, welts, asthma symptoms, and dizziness. Tell your doctor about medical history, muscle or nerve conditions including ALS or Lou Gehrig's disease, myasthenia gravis, or Lambert-Eaton syndrome, and medications, including botulinum toxins, as these may increase the risk of serious side effects. For full safety information, visit BotoxCosmetic.com or call 877-351-0300.
See for yourself at BotoxCosmetic.com.